Good morning. May it please the court. My name is Genevieve Henriquez, and I represent Fort Miami Heights CDC, Numa Construction, and the Henriquez Group, the junior lien holders in this case. I'd like to reserve 2 minutes for rebuttal, please. It is our position, Your Honor.
How many?
2 minutes.
2.
It is our position, Your Honor, that the lower court abused its discretion in failing to vacate the judicial sale and in granting an ex parte order to that effect without permitting an evidentiary hearing which would reveal the irregularities surrounding the sale.
Was that objected to? Was that objected to when the document was filed?
Yes, sir.
It was objected to. The ex parte order was objected at that time when it was filed?
The ex parte order was the final order which ended the matter, so an appeal was filed.
Okay, I'm confused. Was there an ex parte assignment that was filed in this matter, or are you talking about the order?
No, Your Honor. We filed an objection to the sale.
Right.
After we filed an objection to the sale, we asked for an evidentiary hearing. Right. When we went to opposing counsel, tried to have the matter heard on a 5-minute motion calendar. When we got there, the judge noted that she did not have enough time to go over the matter, so opposing counsel asked that the court look at the pleadings that were filed and enter an order, which is what she did.
This point occurred at the very tail end of everything that had gone on, am I correct?
That is correct.
Okay. Okay.
To read the pleadings, all the other parties apparently felt pity for appellants. Bailiff noted that the Fort Miami Heights CDC and the junior lien holders were being manipulated by the county. That the county had no intention of allowing the CDC to complete the project despite encouraging it to secure private financing. Bailiff was also initially concerned that an unresolved reversal issue would, quote, have a chilling effect on the foreclosure sale and that no one would bid except Habitat, the county's hand-picked candidate.
How do you make that leap from the mediations? You're talking about the mediation settlement where they agreed that they were going to bid a certain amount and so forth.
What I'm showing you is the pleadings. Originally, when Fort Miami Heights CDC, when I started to represent Fort Miami Heights CDC, I thought they were paranoid because they made all these accusations and they saw all that was happening with the county and all the efforts they made to develop the land, which did not come to fruition. And I'm letting you know that by the pleadings filing this case, we finally had proof as to the county's intent and that the county had no intention of allowing Fort Miami Heights CDC to actually move forward with this project.
But I mean, the fact that they had agreed that they would bid no more than this and no less than that, how does that chill other people from bidding? The fact that it makes it more transparent what they're going to do, and other people then can act accordingly.
It's called price fixing, Your Honor.
How is it called price fixing? Because your client could have gone in and bid for the property and never did.
Our client could not bid for the property because of the problem with the reverter. There was an reverter.
That's something that would affect not only your client but everybody else, and that's something. That's like saying they won't bid on the property because it's in a state of disrepair. I mean, no. That's the way the property is.
No, Your Honor. The reverter, if the reverter did not get an extension, then anybody else who bought the property would be subject to this reverter.
And it was a 3-year reverter, am I correct? Anybody who bought it, pursuant to court order, is going to be subject to a 3-year reverter.
There was a clarified order granted by the lower court which attempted to level the playing field after the settlement agreement was entered. However, that clarified order was not filed and recorded until 1 day before the sale. That order was discoverable August 11th. The sale was August 12th. Fort Miami Heights
actually recorded a week before the sale.
It was recorded. It was docketed and recorded on the 4th. After we took it back to the court and asked the court to re-enter the order, because the order was originally entered on June 19th. It was never docketed. When it was discovered that it was not docketed, the court signed the order August 4th, August 8th, I believe it went back down to the clerk. It was docketed and recorded, but it was not discoverable because I believe that was a Thursday. The sale was on the Wednesday, and so it was not discoverable because when you record the document, it does not immediately show up on a title search.
But how does that enter into, I'm confused as how this enters into what's going on here. The court allowed a 3-year reverter for anyone that purchased the property. It was recorded. Your client didn't go in and bid anyway.
My client had a loan commitment subject to seeing independently that in fact the court had granted this extension on the reverter. The clarified order was not discoverable in a title search. It was not recorded. It was nowhere there. So we could have given the potential lender...
Your client was at the hearing where the court said that... Your client was at the hearing where the court said that everybody's going to get every bidder is going to get a 3-year reverter.
The client was present, but the lender was not. And the lender is not going to rely on what is being reported back to him.
Well,
the lender
it was your obligation, counsel, at the hearing to prove a gross abuse of discretion, correct, in order to obtain relief on your motion?
There was no hearing had, Your Honor.
Was there not a non-evidentiary hearing?
There was no hearing had. We scheduled an evidentiary hearing, and the judge opposing...
Was there a non-evidentiary hearing?
We scheduled an evidentiary hearing.
Was there a hearing?
No, Your Honor, there was no hearing. The judge just said that we cannot hear this on a 5-minute calendar. We will have to find some time to hear this matter. Nobody was able to make an argument. I made an argument that I had filed for an evidentiary hearing and that the matter should not be heard on the 5-minute calendar. And the judge determined that she was going to find time for us to have the hearing prior to the scheduled evidentiary hearing. That did not happen. So no argument was had.
The motion was denied without a hearing?
That is correct.
Your client did have 14 months to redeem from the final judgment, right?
My client did have time to redeem, but the clarified order was not entered until June 19th. The original summer judgment was entered June 2nd. Actually, the hearing was June 2nd. The order was entered June 19, 2008. The settlement agreement was entered into February 20, 2009. Objections were filed to the settlement agreement. After the objections were filed, the judge was concerned that the settlement agreement would in fact have a chilling effect on the sale. Therefore, she entered a clarified order which made it clear that anybody who was a potential purchaser would get the 3-year reverter. However, nobody's going to go in and buy a 15-acre parcel of land in excess of $1.2 million and not know that they were not going to have to contend with the county. This is the same argument that DLS turned around and said they were having.
The problem with that argument is your client was at the hearing, your client knew an order was entered. Your client should have looked to make sure it was filed. If it wasn't, go get a copy and give it to the lender.
That's exactly what we did. But
then why didn't you bid?
Because the lender needed to have a title search done. They wanted
a title search. Go ahead.
The lender wanted to make sure a title search has to be done. They needed independent. Remember, we had Pacific Bank that gave us a commitment back in 2007. Pacific Bank came around and said, okay, fine, we want proof that the reverter was in fact extended. OCD gave us a letter saying that the county had no interest in pushing the reverter or shortening the reverter or acting thereon. Right. Pacific said, no, that's not good enough. We want the county to give us something. So the resolution was passed by the county. 3 resolutions were passed, giving us incremental extensions on the reverter. Right. I think 4 months, 3 months, and 2 months.
You had 5 years at the beginning.
Originally, it was a
5 years.
Originally, back in 2001, there was a 5-year reverter. And remember, when HUD gave the land to the county to be conveyed to the CDC, there was no reverter attached. And it was 19 acres of land. The county gave 5 acres in transition, no reverter was added, gave 5 years to the CDC and added that reverter.
But then because your client hadn't gotten it done, in order to get 2 more extensions, the county said, look, there's going to be a reverter and we want a quick claim deed to hold on to it. If you don't meet this, we're going to file it.
No, Your Honor, the reverter was already in place from 2001.
Well, that makes it even more so. And then there was a quick claim deed that was held on to. And if your client didn't meet their obligation, I mean, how long did your client want?
The client...
Your client had 8 years.
Your Honor, the client... 5 years... When the deed was given in 2001, they had 5 years. The county was supposed to provide technical support as well as loans for the building of the property. They provided them with end loans, no construction funds, even though they provided in transition with construction funds. So my client went out and secured private financing. After the private financing was put in place, and then they got the construction loan in 2007. This is when they went back to the county after AHAB had given them an extension to 2011. They went back to the county and asked the county to ratify AHAB's recommendation for the reverter. In 2007, when Pacific Bank gave them that loan commitment for $1.8 million to do the bridge to the financing, Pacific claimed that they needed the resolution given at least a 3-year reverter. At that point in time, they gave them a reverter from July to December. Pacific said that's not enough. But one of the conditions of that reverter was that financing had to be in place. Financing was in place. There was financing in place because they had gotten a loan commitment from Pacific National Bank. When Pacific National Bank met with the county and asked, could they get a longer extension because they were uncomfortable with a 6-year extension, they gave an additional 3 or 4 month extension. So they gave them these incremental reversals. No bank was comfortable with that. The final lender, we went back after Pacific dropped out, and we found out that the attorney for Pacific and CEO for Pacific was in fact Habitat CEO and attorney. After they fell out, we went back and had another loan commitment from Wachovia Bank in 2009. Wachovia met with the county and asked the same questions. Again, they did not extend the reverter. While there was a reverter in place until July 31st, 2008, the county passed a resolution on July 17, 2008, giving the property to South Miami Heights CDC, not South Miami Heights, Habitat, and giving them a 3-year reverter. Habitat is a stranger to this property. South Miami Heights CDC had been paying taxes on the property from 1994. And here comes Habitat, a stranger to the property, and they get a 3-year reverter when the CDC has now come to them, given them a commitment, and told them all they need is a sensible reverter. They never did what they were supposed to do. They were supposed to provide the CDC with technical support. They were supposed to provide the CDC with money, just like they did in transition. They never did that. So the South Miami Heights CDC was behind the 8 ball. Nevertheless, they got all of these things. So from 2007, had they gotten that 3-year reverter, the loan could have closed, and they could have completed the transaction.
Was all this raised as an affirmative defense to the foreclosure action?
All of that was raised, Your Honor.
All of that was raised as affirmative defenses to the foreclosure action?
Correct, Your Honor, and that is why we asked that the county be joined as an indispensable party, because originally they were not joined.
Well, let me ask you, because in order to set aside the sale, going back to Judge Shepard's first comment, you got to show some misconduct or something that rises to that level. Grossly inadequate sales price, that's not it. And mistake or misconduct. Fraud. What is there? I think your allegation was there was fraud. You alleged fraud, collusion, and price fixing. What proof did you have of fraud, collusion, and price fixing?
The settlement agreement by itself stands to show that there was fraud and collusion. They would turn around and ask us say that we are misreading that. Here is a situation where you have a land that's worth over $6 million.
It's not worth over $6 million anymore. It's
not.
No. Based on the appraisals, it's not worth that.
We don't know that it's worth now, but back in 2009, we had the county appraisal. 2009 September, we had not gotten the 2009 appraisal, but 2008 county appraisal was out, and that showed independently that the land was worth $6.3 million. Then comes Habitat and BLS. Habitat is to bid only $1.2 million. The same amount of money they offered South Miami Heights CDC to buy the property, which had $5 million in equity. They're only allowed to bid that. BLS could not bid more than $1 million.
Habitat for Humanity could only bid $1.2 million and couldn't go above that?
They agreed to only bid 1.2, and they were...
But anybody could have come in and bid above that, am I correct?
The problem comes back to the reverter. If this did not have a reverter attached to it, the reverter becomes the problem. If there was no reverter attached to this, then anybody could have come in to bid.
I understand. I understand what you're saying. Yeah, go ahead.
No investor is going to come in and buy this land. Because DLS, when they could have foreclosed and got their money and walked away, decided they themselves said that there was a chilling effect on it. So they wanted to work with the county to get their reverter taken off. They knew. They had the commitment. They had the deed. They knew. Somebody else is going to come in and say, okay, whoops, 15 acres of land. Okay, what can I buy this for? But no, here's a reverter. What am I going to do? Here's the settlement agreement, which is in the court records. And by the way, some of the court records, some of the pleadings were missing. We don't have a clarified order, which makes it clear that whoever buys also gets a 3-year extension on the reverter. So now they're going to buy this property and have to go fight with the county. And it's the same county that has made it clear that we will be back because they will get a dime.
We've used up 15 minutes. But we'll still give you a little time for rebuttal.
Thank you, counsel.
Thank you.
Good morning, Your Honors. Jorge Martinez de Seve, together with Deborah Herman, Assistant County Attorneys on behalf of Miami-Dade County. Frank Sinagro, Counsel for Bankers Lending, has ceded his time to the county, and Richard Rosenthal, sitting here before you, is the attorney for Habitat for Humanity, and he's asked for 2 minutes at the conclusion of my time. So once again, I'll wish you good morning. Once again, Ms. Enriquez made 3 misstatements while she was standing up here, and they were based on 3 pressing and pointed questions that Your Honors asked them, so I wanted to clarify. Lastly, Judge Suarez, you asked her whether Habitat was capped in their bid, and although she said that in her brief, the agreement says otherwise. The only party that agreed to cap its bid was the lender, as lenders often do with these foreclosure sales.
Agreed to go up to $1,009,000 something.
1,199.
Habitat would be 1.2.
A floor. So in paragraph 7 of the agreement, it says if Habitat fails to bid at least $1,200,000, it only set a floor and not a ceiling. So that's one very important fact that Ms. Enriquez misstated. The second thing is, Judge Shepard, you asked her about why the order wasn't filed, and although she told you that it was not re-entered by the court and refiled for 1 week before the sale, which I would say is still sufficient under the law, what she didn't tell you is that on 3 prior occasions, the county twice filed the order, once in the form of the transcript of the hearing where the court made the oral pronouncement. That was filed on June 23rd, a mere 4 days after the order was originally entered. The county filed a transcript in the court file. Then a couple of weeks later, on July 7th, the county filed the actual order itself in seeking reconsideration, filed that in the court file. And then lastly, she didn't tell you about it, but Ms. Enriquez herself, on July 29th, filed a copy of the order and said, Your Honor, this order has not been docketed, and I ask you to re-enter it so it can be docketed. So all of the parties, as you said, not only were present at the hearing, Your Honor, a transcript was ordered and distributed, and the order itself made it into everybody's hands. The clerk may have misdocketed it, but everyone had it, and multiple parties, the county and Ms. Enriquez, put it back into the court file, where, as this court has repeatedly held, anyone bidding at a foreclosure sale is on notice of all of the proceedings and orders that are entered and in the file. So she didn't tell you that, but there were 3 different places where that order could have been found and would have been found, even ignoring the fact that a week before, for a 4th time, the court's re-entered order was also placed in the file. So that's the second misstatement that she made. And the third was with regard to the reverter, and the reverter was extended to all parties. Now, she's asking you to believe that reverter was not extended for everyone, but it was extended for everyone. And lastly, Your Honor, with regard to the hearing not being held, Ms. Enriquez herself in her brief places a block quote, which I also inserted into the county's brief, and it's at page 8. And it's from the transcript of the hearing. It's in her appendix, Exhibit EE at page 7 through 9. And this is Judge Leesfield at the hearing that Ms. Enriquez is present at. And she says, I remember this case well. I really pulled you, and that's referring to Ms. Enriquez, and your client out of the fire the last time we had a hearing. I'll skip over a portion of it, but it goes back and she says, so I'm going to hear this. I want to take a look at it, which I haven't done, and make sure the defenses that you raised would even be defensible or even raisable before I tie this piece of property and $1.2 million up until November for a whole other month. She then proceeded to have a hearing. where she considered the very same arguments that Ms. Enriquez made in her brief before this court, and she rejected them for the second time, Your Honors. So for Ms. Enriquez to stand up and say that this was done ex parte or without a hearing, where she herself has included the transcript of that hearing, baffles the imagination. I'm not sure why she makes that argument, but there was the last in a series of hearings before Judge Leafield and Judge Jensen before her. This case has been heard ad infinitum and ad nauseum by multiple judges, and these allegations have been heard and vetted. So now she has to show a gross abuse of discretion, as Your Honors pointed out, which she can't do. She can't show an inadequate sales price, Your Honors, because, as you pointed out, I think, Judge Suarez, the appraisal that was in the file was for $3.6 million. That's in August of 2006, at the very height of the real estate boom. What's the relevant date here? August of 2009. Perhaps the beginning of the depth of the market. And yet the sale price was $1.2 million. So I would submit to you this court has held in Moody, which I cited in my brief, that really it's a nominal sales price that this court is going to look to show inadequacy of price. Here, her best case argument is that it's a third of the price. And I cited to you...
This property can only be used for low-income housing?
That's correct, Your Honor. There is a restriction. In addition to the reverter, there's a use restriction which requires it, even though it's 15 acres, it can only be built out as 45 affordable housing units. And that's one of the factors, as I said in my brief, that I think any bidder at a foreclosure sale is going to take into consideration. I'm not unfettered in what I can do with this property. I'm limited to 45 affordable housing units, which can only be sold at a certain price because they have to meet certain criteria. So the return for an investor was going to be limited, and really the pool of bidders would have been limited by that too. So it's those market forces and the fact that the sale is occurring at the nadir of the market that control the bidding. The bidding was not controlled by the settlement agreement. The only party whose bid was controlled by that settlement agreement was the lender, which is standard practice in foreclosures and happens all the time. They agreed to limit the amount they bid, but neither Habitat nor the county nor BLS nor anybody else was limited in any way in bidding at the sale.
Mediation, where those amounts were agreed to, South Miami was not excluded from participating in that mediation, right?
They were present at the mediation, Your Honor. They were aware of the settlement agreement at the time. The settlement agreement was never hidden from anyone. It was spoken about and argued about in court. It was not a secret agreement, as you know, with the public records law being as broad as it is. There was no secret about the settlement agreement. All parties were on notice as to what the terms of it was and what it called for and how it would play out. So any potential bidder would have known about the limitations that Bankers Lending has placed on its own bidding. So without being able to show the gross inadequacy in sales price, there's no need even to reach the second prong, which, as Judge Suarez said, is mistake or fraud. And these arguments that she's made, I had moved to strike the brief earlier because there's no record citations to support them, Your Honors. I would submit there's no evidence to support them. But the complaints that she has, as Judge Suarez suggested, are complaints that, even if true, predate the foreclosure judgment. The foreclosure judgment which Bankers Lending brought against South Miami Heights. They didn't pay their mortgage. They didn't comply with a 5-year reverter. The other thing I wanted to tell you, Judge Suarez, and it's in my brief, is not only did the county give her 5 years initially, they gave them just under $1 million in grant money, not loan money, a grant. There's nothing to show for it. This land is lying fallow as it's been for the last 12 years. So they got shy of $1 million in 5 years to do something and did nothing. They also, as I said in my brief, encumbered the property with 3 mortgages without getting the county's consent, as is required by law. The county did not subordinate its reverter interest to any of those mortgages because we were never given notice that they were encumbering the property with mortgages. So if there's any party that's acted inequitably, I would submit to you that it's the junior lien holders in South Miami Heights. The rest of the parties have done, out in the open, what we've shown you through resolution, tried to get a reputable developer, in this case Habitat for Humanity, who can finally put into action the intent of the board, which is to develop affordable housing in this area which needs it desperately.
We have 2 minutes, I guess.
Thank you very much.
Thank you, Counsel.
May it please the Court, Richard Rosenthal on behalf of Habitat for Humanity. Your Honors, unless you have additional questions, I'm not going to belabor matters because I think the Assistant County Attorney has done a fine job of explaining the situation here. I would only amplify one point that is raised in our brief that I think bears mention. This plot of land was originally deeded back in 2001, January 5th, 2001. Here we are 11 years later. The property is still lying fallow. It's an open field. It was intended for affordable housing for this community that desperately needs it. We've undergone in the intervening 11 years one of the worst economic crises in our nation's history. When the need for...
We've been told all that. Do you have a legal point to make?
I don't. Unless you have questions, I'll sit down.
Thank you, counsel.
Just to rebut Mr. Martinez, my brief gives you a copy of the transcript. There was no hearing. The court says, I'm going to hear this, but there's no hearing. 4 pages. The appraisal was given by Miami-Dade County in 2008. The land was appraised at in excess of $6.3 million. Settlement agreement, we were present at the first mediation. There was no settlement agreement at that time. We were told we were there as an appendage. We were not necessary, and so we did not participate in the settlement agreement. As to the grant money, South Miami Heights CDC got $96,000. Money was set aside for South Miami Heights CDC, but they were all recaptured. And as to consent, and the reason why the land has remained fallow, the county failed to help South Miami Heights CDC in its agreement when it conveyed the land that it would provide technical support as well as loans to have this land developed. South Miami Heights CDC went out on its own and it put in infrastructure, the pump station, paid taxes, over 1.8 non-county funds as indicated in the resolution has gone into the land which belongs to the junior lien holders. They should not be robbed of this money because Habitat decided it was going to bid no more than $1.2 million for this property, which had at that time in excess of $5 million in equity. Thank you very much.
Thank you, counsel.